Hello, I accept LP's Virtual Law Review Challenge, and the title of my virtual article is The Use of Force in the Policing of Demonstrations, especially regarding the case law of the European Court of Human Rights, in search for a global rule of law regarding the topic. Well, actually, to properly understand the use of force in the policing of demonstrations, we need a general framework of the rights and freedoms in question. From a human rights perspective, the right to peaceful assembly has a vital role in this respect. There are international and regional legal instruments recognizing the right to peaceful assembly. As you can see from the slide, Article 20 of the Universal Declaration of Human Rights and Article 21 of the United Nations International Covenant on Civil and Political Rights, and also Article 11 of the European Convention on Human Rights uh, uh, recognizes the right to peaceful assembly. According to the Article 11 of the European Convention on Human Rights, everyone has the right to freedom of peaceful assembly and to freedom of association with others, including the right to form and to join trade unions for the protection of his interests. And in the course case law, as you can see, not every assembly constitutes a protest, although a protest is the most restricted type of assembly and therefore must frequently constitute the subject of applications to the court under Article 11. The right of freedom of assembly, peaceful assembly, covers both private meetings and meetings in public places, whether static or in the form of a procession. The right can be exercised by individual participants and by the persons organizing the gathering. However, Article 11 of the Convention only, as I said, protects the right to peaceful assembly. Um, in this regard, of course, I should mention about the restrictions uh, on the enjoyment of this right. The court has held that the term restrictions in paragraph 2 of Article 11 must be interpreted as including both measures taken before, during, or uh, after the protests. So the forms of interference indicated most commonly present in the context of mass protests. According to the case law of the European Court of Human Rights, forms of interference are refusal to authorize an assembly, preventive arrest to ensure non-participation in an assembly and refusal of access, and dispersal of an assembly and the use of force, and lastly, the post-demonstration sanctions. But of course, while we are talking about the restrictions, we should bear in mind, according to the wording of Article 11, that the exercise of these rights and the restrictions upon them must be prescribed by law and must be necessary in a democratic society. So, let me repeat once again. This means that restrictions should be prescribed by law and must be necessary in a democratic society. Of course, today my focus will be on the use of force in the posting of demonstrations. But of course, why does the use of force in the posting of demonstrations matters? It is because, as the case law of the European Court of Human Rights suggests, the use of force may result in the breach of right to life, prohibition of torture and inhuman or degrading treatment, right to a fair trial within a reasonable time, and of course, freedom of expression. Not to exceed my time limit, especially if we're talking about 10 to 15 minutes virtual articles. I will try to review the case law of the European Court of Human Rights regarding the use of force in the policing of demonstrations, particularly in terms of the right to life and the prohibition of torture. I picked two judgments of the European Court of Human Rights, and one of them is Giuliani versus Italy, and the other one is Gaziola and others versus Turkey. So, as you can see in Giuliani and Gaggio versus Italy, it was held by the Grand Chamber in 2011. And also at the same year, the court decision on Gaziola and others versus Turkey. First of all, let me try to review Giuliani and Gaggio versus Italy. It is about the death of a demonstrator at the 2001 G8 summit in Genoa. On 20 July 2001, during an authorized demonstration, extremely violent clashes broke out between anti-globalization activists and the law enforcement agencies. Carlo Giuliani, who was wearing a balaclava, according to the press release of the European Court of Human Rights, and was playing an active part in the attack, was fatally wounded by a bullet to the face. In an attempt to move the vehicle away, the driver drove twice over the young man's body as he lay dying. When the demonstrators had been dispersed, a doctor arrived at the scene and pronounced Carlo Giuliani dead. Relying on Article 2, the applicants alleged that Carlo Giuliani's death had been caused by excessive use of force, that there had been shortcomings in the domestic legislative framework, that the organization of the operations to maintain and restore public order had been defective, and finally that there had been no effective investigation into Giuliani's death. While justifying the use of lethal force, the court noted that the officer who had fired the shots had been confronted with a group of demonstrators conducting an unlawful and very violent attack on the vehicle in which he was stranded. In the court's view, he had acted in the honest belief, the police officer acted in the honest belief that his own life and physical integrity and those of his colleagues were in danger, from the attack to which they were being subjected. Moreover, it was clear from the evidence of the court's disposal that the Carabinieri had given a warning while holding his weapon in a clearly visible manner, and that he had fired the shots only when the attack had not ceased. So in those circumstances, the use of a potentially lethal means of defense, such as the firing of shots, had been justified. The court also simply observed that the officer could only fire in order to defend himself into the narrow space between the spare wheel and the roof of the Jeep. The fact that a shot fired into that space risked causing injury to one of the assailants or even killing him, as had sadly been the case, did not in itself mean that the defensive action had been excessive or disproportionate. So the court therefore concluded that the use of force by the Carabinieri concerned had been absolutely necessary within the meaning of the convention, and that there had been no violation of Article 2 in that regard. And also the court noted the applicant's allegation that some Carabinieri had used non-regulation weapons against the rioters, but saw no connection with the death of Carlo Giuliani. So accordingly, there had been no violation of Article 2 with regard to that complaint. And also, the Italian authorities had not failed, according to the wording of the decision of the European Court of Human Rights, the Italian authorities had not failed in their obligation to do all that could reasonably be expected of them to provide the level of safeguards required during operations, potentially involving the use of lethal force. So, again, the court found that there had been no violation of Article 2, right to life, in this respect. Well, I guess the judgment of the court is questionable because when you read the wording of the judgment, there are so many points that should be questioned. Of course, it's up to the reader once again, but I guess that as a positive obligation, Council of Europe member states, not only Italy, has the obligation to protect the right of the citizens. So this is a positive obligation, no matter what. Now let's jump to the second case. It is Gaziol and others versus Turkey. It's about unjustified police intervention in demonstrations regarding prohibition of torture. The applicants in this case are four Turkish nationals who live in Istanbul. In October 2003, they took part in a demonstration against the war in Iraq, which was dispersory by police officers. The applicants were arrested and taken into police custody, where they remained until their release the following day. They alleged that they were subjected to ill treatment during their arrest and detention. Relying on Article 3, the applicants in this case complained that they were ill-treated by police officers who arrested them, and also in particular relying on Article 11, the applicants complained that the police intervention violated their right to freedom of assembly. The court considered that the injuries sustained by Ms. Gazioğlu and Mr. Chanel, namely in the face and on the head, had attained the minimum level of severity to fall within the scope of Article 3. It was apparent that no serious attempts had been made by the prosecutor to establish the circumstances of the use of force or the cause of the applicant's injuries. Although the identification numbers of the police officers involved in the dispersal of the demonstration had been included in the incident report, they had not been summoned or questioned by the prosecutor. Having regard to the fact that no other justification had been given by the government for the use of force, than the allegedly rowdy behavior of some of the demonstrators and of the fact that the applicants had not committed any offenses, the court considered that the use of force by the police officers resulting in the two applicants' injuries had been disproportionate. There had been accordingly a violation of Article 3 in respect of Ms. Gazioğlu and Mr. Chanel. So in this case also regarding Article 11, the government didn't dispute that there had been an interference with the applicant's right to peaceful assembly. As regards the question whether the interference had been necessary in a democratic society for the purpose of Article 11, the court reiterated that where demonstrators did not engage in acts of violence, as had been the case with the applicants in both cases. So it was important for the public authorities to show a certain degree of tolerance towards gatherings if freedom of assembly was not to be deprived of all substance. So the court, in this case, therefore considered that the police interference with the applicant's right to freedom of assembly had been disproportionate to the aims pursued and thus in violation of Article 11. So, once again, I guess we all should think about the rule of law, especially when we think about the positive and negative obligations of the states from a human rights perspective and the use of force in the protests. So uh, I hope this virtual article uh, helps you to ask and maybe answer a couple of questions in search of rule of law. So thank you for listening to me.